So the Supreme Court just issued their decision on multiple Second Amendment cases, and they also issued a ruling which will impact the ATF Second Amendment violations. So let's talk about this. But real quick before we jump into this video, if you think it's time to strike down all these Second Amendment violations, go ahead and hit that like button and subscribe. Also thank the sponsor of this video, which is Teslong. Teslong was founded in 2009 as a manufacturer of innovative digital products that solve problems for all sorts of consumers. Their products started with industrial endoscopes, but they have since expanded into the firearms world with their rifle borescopes. Their borescopes come with a variety of attachments so that you can get a clear HD image of what is going on within your rifle internals. Their rifle borescopes are compatible with most devices, including the iPhone, Android, laptops, etc. So if you're interested in checking them out, I will leave a link to them down in the details section. And thank you again, Teslong, for sponsoring this video. So like I said in the intro, today on the last day of the Supreme Court's term, we got some more major good news for the Second Amendment. The Supreme Court has decided what they want to do with various Second Amendment cases that were on hold. But the Supreme Court did not just stop there. They also issued a ruling in an EPA case that has major impacts on other agency actions like those performed by the rogue ATF. So first, let's talk about the cases that were on hold and what happened with them and what the Supreme Court did. And then I want to break down the West Virginia v. EPA case and what impact it will have on the Second Amendment. So the cases on hold before the Supreme Court that have now been impacted by the Bruen decision were Duncan v. Bonta, the California magazine ban case, the ANJRPC New Jersey magazine ban case, the Bianchi v. Frosch Maryland assault weapons ban case, and the Young v. Hawaii open carry case. Last week, the Supreme Court issued a decision in Bruen which struck down New York's May issue permitting scheme and also rejected the two-pronged approach that lower courts have since been using and relying on to uphold various Second Amendment violations. The Supreme Court in Bruen reaffirmed that text, as informed by history, is the correct type of analysis when you're dealing with the Second Amendment. Because of that ruling, the question became, what would the court do with all of these other Second Amendment cases that were on hold before the Supreme Court? Well, we received an order today from the Supreme Court, and it essentially issued GVRs in all of these cases. Now, if you're not aware of what a GVR order is, it is a type of order issued by the Supreme Court in which the court grants a petition for certiorari, vacates the decision of the court below, and remands the case back down for further proceedings. So that's why it's called a GVR. It's a grant, vacate, and remand. An order of this sort is typically appropriate when there has been a change in legal circumstances subsequent to the lower court's decision. That is exactly what has happened here, and that is why these cases have been granted, vacated, and remanded because of that Bruen decision. So here's the order from the court in the Young v. Hawaii case and the Duncan v. Bonta case. It states, the petitions for writs of certiorari are granted, the judgments are vacated, and the cases are remanded to the United States Court of Appeals for the Ninth Circuit for further consideration in light of the New York State Rifle and Pistol Association v. Bruen case. So those cases are heading back down to the Ninth Circuit for a new decision in light of the Bruen opinion. The order in Bianchi v. Frosch is the same, except it remands the case back down to the Fourth Circuit where it came from. And the ANJRPC magazine ban case out of New Jersey is also remanded back down to the Third Circuit where that one came from. So this was a solid win for the Second Amendment. The best case scenario would have been that the Supreme Court would take up some of these cases and finally issue an official ruling on some of these issues, but this was kind of the second best option. Now the lower courts are being told that their prior decisions in these cases were incorrect, they've been vacated, and now they must rehear these cases and issues in light of the correct analysis as outlined in the Bruen opinion. Now what will happen from here is that the circuit courts in these cases will ask for additional briefing in light of the Bruen decision. This should be a pretty straightforward process from here on out if the circuit courts adhere to the Supreme Court's opinion. But we have learned from the Ninth Circuit and some of these other circuit courts is that they're not always willing to actually adhere to what the Supreme Court says, and sometimes they openly defy what the Supreme Court says in their opinions, like they did with Heller and McDonald. So these cases are heading back in the right direction. They've been remanded back down to the circuit courts, and now we have to see what the circuit courts are actually going to do. Are they going to adhere to Bruen, or are they once again going to openly defy the Supreme Court? Now let's talk about the Supreme Court's ruling in the West Virginia v. EPA case. In this case, the Supreme Court issued a 6-3 opinion authored by Chief Justice Roberts. The question in this case was whether Congress gave the EPA broad authority to regulate power sector greenhouse gas emissions, or is the agency's authority to regulate more limited? Well, this decision by the Supreme Court found that Congress did not grant the EPA authority to regulate greenhouse gas emissions in virtually any industry however they want. Now, although this case dealt with the EPA as an agency, this case and ruling has much broader impacts. Really, this is about what authority do executive agencies have. In reaching their decision, the Supreme Court said this case involved the major question doctrine. Congress frequently delegates authority to agencies to regulate particular aspects of society in general and broad terms. However, in a number of decisions, the Supreme Court has declared that if an agency seeks to decide an issue of major national significance, its actions must be supported by clear statutory authorization. Courts, commentators, and individual Supreme Court justices have referred to this doctrine as the major question doctrine or the major rules doctrine, although the court has never expressly used that term in a majority opinion until now. As Justice Gorsuch stated in his concurrence, to resolve today's case, the court invokes the major question doctrine. Under that doctrine's terms, administrative agencies must be able to point to clear congressional authorization when they claim the power to make decisions of vast economic and political significance. This ruling is important because the arrival and use of the major question doctrine, like Justice Gorsuch just stated there, strikes a major blow to the Chevron deference doctrine. The court traditionally has treated the major question doctrine as an exception to the Chevron deference doctrine. Chevron deference and that doctrine governs judicial review of agencies' interpretations of a statute. If Chevron applies, a court will typically engage in a two-step analysis to determine if it must defer to an agency's statutory interpretation of an ambiguous term or statute. At step 1, the court asks whether the statute directly addresses the precise issue before the court. If the statute is ambiguous or silent in that respect, the court must proceed to step 2, which instructs a court to generally defer to the agency's reasonable interpretation. So essentially under Chevron, if there's an ambiguous statute or term, and there's a determination that's ambiguous by the court, then they simply defer to what the agency says. However, under the major question doctrine, when an agency's interpretation of an ambiguous statute concerns an issue of vast economic and political significance, the court must deny the agency the deference traditionally afforded to them under Chevron. Now let me explain why the use of the major question doctrine is very important for the Second Amendment context. Currently, the ATF has engaged in various actions claiming that under the vague statute language in the NFA and GCA, they have the power under Chevron to make rules and decide what those statutes actually mean. This has resulted in various ATF actions like their actions in banning bump stocks, their new rules on frames and receivers, their new pistol brace rule, and their attacks on various triggers, and so many more other things that they've done. What the Supreme Court is saying in this decision is that agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Instead, the court is now establishing that if Congress wants to give an administrative agency like the ATF the power to make these types of decisions, it must state that fact clearly and expressly in the statute. So all the actions that the ATF is engaging in because of claimed vague language and under the protection of Chevron deference is now invalid. They cannot do these things unless the statute and Congress expressly state that they can. So although this decision did not just completely throw out Chevron deference in that landmark case there, it did drastically change how executive agencies must operate here on out and how courts will actually defer to what an agency is doing. Now, currently there are 2 ATF cases that are at the Supreme Court level, and both of those deal with bump stocks. Those cases are the Apashian case and the GOA case. Those cases have not been resolved this term, so now they will be in a limbo phase and they will go into next term, and we'll have to wait and see what the Supreme Court wants to do with those in their next term. But overall, we got some solid wins today, and during this year, we got some big wins by the Supreme Court. A lot is going on right now. A lot is being changed going forward. A lot of these things in the Second Amendment context are changing in other contexts as well. So I implore you guys, please stay tuned to the channel. Make sure you're subscribed because things are happening rapidly. A lot of these cases are going to be now moving forward at a lightning pace. And just make sure you're subscribed, tuned into the channel because a lot of these things are changing. And I'm going to try to get you guys the information as fast as I can. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever on my own. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by Armed Scholars, and this nation will be maintained by Armed Scholars.